Yes.
You have to do 2 every
week.
Yeah.
Even if someone earns 5,000 Ghana cedis every month, that person cannot keep paying 380 cedis 3 times a week for dialysis.
Majority of the people who need dialysis to survive in Ghana don't even earn half of the amount mentioned.
Some people battling organ diseases end up losing their jobs because their companies cannot keep paying.
Look at page. You didn't even page your table of things. But you made reference to North versus London County Council 1994.
Yes.
I don't know, you didn't page your you didn't page your table of things, but it is there. What you are reading. I just want you, because you said you have relied on your table of kings.
Yes.
Naturally, we have read it, or we will read it. You have anything to add?
Yeah.
Essentially different from what you have here. Yeah. But you seem to be saying the same, repeating what you've just written. And you were just, it looks like you wasted our time if you continue to do that.
Respectfully, Your Lordship, the question that my Lord raised is what is at the heart of this review. That having so determined that the dogs did not belong to the second defendant company and they were not keeper or owner, the law is established that it is only the keeper or owner who is liable in negligence. First, who owes a duty and also is liable in
How about the owner of the premises?
My Lord, that's what we're saying, that the case makes it very, very clear that the owner of the premises.
That's not what's done.
Yes, my Lord.
You have referred to North versus London County Council in your statement of case.
My Lord, that particular reference was in respect of a particular ground which had to do with leaving. My Lord, this is the point that it says in Smith versus Great Eastern Railway Company.
So hold on.
Yes.
Let me read yours, part of your statement of case to you, which is not A. The last verse, 1, 2, 3, 4, 5, 6. You said, my Lord, grounds 3 became relevant for consideration, having regard to the fact that the first appellate court rested its decision of imposing liability on the applicant on the strength of the authority of North versus London County Council. Yes. So, and you go on to quote, a person who owns a dog so and so and is kept in a manner that will restrain so and so. What is a different point you seek to make now?
Yes, Your Lordship, in placing reliance on the North case, what this court was referring to was that the court had come to an assumption, an erroneous statement that the first defendant and the second defendant were both owners of the dog. It is that which, unsurprisingly, led this court to the error it made in respect of who bears the legal duty. Your Lordship, because if you look at
how do you fit this in a ground for review?
My Lord, the ground for review.
It's not, bear in mind that it's not an appeal.
Yes, my Lord. This is the first time we're raising that question, that there must be a distinction between the first defendant and the second defendant. That is why we raised this ground of appeal. And that this
ground, I like that, ground of appeal. That's why you raised this ground of appeal. Your Lordship, for the ground of appeal.
No, not for the ground for review. And that the main point is that in this court, in the ordinary bench, even though it had found as a fact that it was the first defendant who was the owner and the keeper and the controller of the dog, still proceeded in conclusion to say that the dogs were, it was the defendant's dog, and therefore fixed that liability, the duty of care, on the second defendant, when the second defendant in law had absolutely no duty. And my lordship,
So are you saying, just for the sake of argument, that who had the duty, the first defendant, not the second defendant?
absolutely. So we have not tried to relitigate, even though respectfully we disagree.
And the first defendant is an employee of the second, just to put this.
Yes, there's a director of the
first is a director of the second defendant.
Correct.
So the liability you are saying is for the first defendant, not the second defendant. That's what you are saying.
Absolutely.
A case. So we are live at the Supreme Court of Ghana, where is Alexander Afeomakin, who is the leader of the NPP caucus in Parliament, versus the Speaker of Parliament and the Attorney General. The case was heard a short while ago, but counsel for Alexander Afeomakin was led by Joe Gatti, who is MP for Ketan, and Samuel Atachan, MP for Ibuakwa South. The counsel for the Speaker was led by Thaddeus Sori and Edem Strai. And then also the Attorney General himself, Godfrey Yabua-Dame, assisted by his colleague Alfred Tuyayabua and a host of other members of the bench of the bar were in attendance. Now, preliminary objection was raised by the Attorney General, Godfrey Yabua-Dame, regarding the process the Speaker and lawyers for the Speaker, in fact, had served the Supreme Court following their receipt of the bailiff from the Supreme Court on the Supreme Court's decision for the Speaker to stay execution regarding his declaration of 4 seats of members of Parliament vacant based on their intention to file as independent members of Parliament and on the ticket of the NPP. Now, if viewers will recall, this matter has become very topical in the last couple of weeks following the application by the leader of the NDC caucus, Dr. Kestolato Forsen, to the Speaker that 4 members, member for Aguna West, Cynthia Mamle Morrison, member for and then 2 other members had filed as independent candidates. Now, Cynthia Mamle Morrison had come on the ticket of the NPP to Parliament, and then the member for Suhum had also come on the ticket of the NPP. We also had a member for Honorable Aka, who had also come on the ticket of the NDC. These members had gone as independent candidates for the 2024 elections. And then the second Deputy Speaker, Andrew Samuel-Kwesiama, who came as an independent candidate, had also switched camps to join the NPP in the 2024 elections. Because of this, the leader of the NDC caucus, Dr. Atuforsen, prayed the Speaker to declare their seats vacant. Those seats, the Speaker, after 2 days of consideration, declared vacant. After this, the leader of the NPP caucus, Alexander Afeomakin, MP for Efutu, also took a suit to the Supreme Court for the Speaker to stay execution of the matter in order for the court to also have time to determine the constitutionality of declaring such seats vacant in an upcoming election, because according to him, the constitution was not so clear on that matter. Now, when the case was heard at the Supreme Court last 2 weeks Friday, the court called on the Speaker to stay execution of that ruling, i.e. for the members to act in their capacity as sitting MPs and not have their seats vacant, as the court took consideration of the substantive matter. Now, after this, the courts had to serve the Speaker notice of the ruling that they had done to stay execution. Mr. Speaker and through his lawyers, Thaddeus Sori and co., also wrote back to the Supreme Court that their service was contrary to a ruling the court had earlier made in July, whereas as custom is, the parliament does not sit on Mondays, and so the court had ruled that in 7 members of parliament or the speaker are done on a Monday. So the process that the Thaddeus Sorry, lawyer for the Speaker of Parliament, had written to the Supreme Court was to the effect that the service that was done by the court was not done on a Monday, and it was in contravention of the court's own ruling. And so today the court is sitting on the matter, but just as the substantive matter was to be raised, the Attorney General Godfrey Abuadam rose an objection in terms of what Thaddeus Sorry, lawyer for the Speaker Court, and in the objection they noted that they found it rather disingenuous for they found it rather disingenuous for the court and Thaddeus Sorry to insinuate that the Chief Justice should have been privy or should have known exactly what the earlier ruling was, and so the Chief Justice, who is leading the panel, the 5-member panel of the bar, including Justice Johnny Kudendi, thought it was a bit unfortunate for Mr. Sorry to make such an assertion. And so that is what has happened and transpired in court, with Mr. Sorry making his submission, and after the AG had also made a submission. Now the panel headed by the Chief Justice is going in conclave and has gone in conclave a ruling on this preliminary objection that has been raised. We'll have my colleague Sarah Ofori joining me now. So Sarah, what's going in conclave? How do you make of this whole situation now?
Well, I believe this is a test of democracy. 2 independent bodies, I wouldn't say at loggerheads, but in disagreement with how to interpret the Constitution and what it says. On one hand, it is being said, or the law makes it clear, that the judiciary is an independent body, so is the legislature. So as to the legislative body makes laws and the judiciary interprets the law. But we also know that before a law is made, usually the Attorney General will make inputs before it's laid before Parliament for consideration and for committee work to begin. But in this case, the Constitution is what is being tested. Parliament has its own, the judiciary has reversed that ruling, and case is a test in our democracy to find out how best we can move forward when such conflicting situation or right. The court proceedings is ongoing. The lawyer for judiciary body. So in this case, the judiciary has no powers or has no rights, for want of a better expression, to overturn its ruling. So, I mean, this is a test of our democracy, and we live to see the outcome of this case. And I know Ghanaians and the media as well, we are all waiting with bated breath to know the outcome of the. In the meantime, we are going back to the courtroom to find out what is happening. My colleague Barbara Kuma is in the court and also monitoring the proceedings from the court. Yes.
We have the preliminary injunction are being forward. What is your expectation for today? Do you feel the to the as the court system?
I mean, that's what we are all expecting, that there will be finality to this matter. But for me, it's a learning process. Who's issues and matters. For years, the also to make provisions for cases that may arise in the future. So for me, and I know that Ghana will stand out tall in all whatever decision is taken by the court today would have future implications, whereby if such an occurrence happens, it's a learning curve. Ghana is a growing democracy, and every instance will test our resolve or our laws to see how far how strong they are, and to see how far citizens can push the law, can stretch the law. Yes.
So, if you are with us and you are joining the Supreme Court of Ghana, a case of fair marking versus the there is from the speech Chief Justice Gertrude Arabatokolu to go with what Sarah says. It's poignant. This is a test of our constitution until and we saw a member from not the ruling party but a member from the opposition presiding. These matters wouldn't have come up, and so in all we see it as a test of the 1992 constitution and a test of the law, and so we are hoping that the rulings by the Supreme Court would inform and shape the nation moving forward. So from now we will leave the forecourt of the Supreme Court and in the chambers of the court itself.
We are both Absunians, and we have agreed that 10,000 cities fair based on the journey. We are both Absunians from St. Augustine's, so 10,000 Ghana
be reconstituted. All rise.
This is the one that did we put a copy on the judge's docket?
Hello, Dr. Asala from Medifem Multi-Specialist Hospital and Fertility Center here. On today's episode on tips about breast cancer, we are going to talk about risk factors. Risk factors are things that put you at an increased chance of developing a disease such as breast cancer. Now, there are modifiable and non-modifiable risk factors. Modifiable risk factors are those risk factors that you can do something about. Examples when it comes to breast cancer include obesity, inadequate breastfeeding, harmful use of alcohol, tobacco use, and radiation exposure. Non-modifiable risk factors are those risk factors that you cannot do anything about. Examples include a family history of breast cancer, age greater than 40, female gender, early menarche, and late menopause. Join us tomorrow for another tip about breast cancer, and on the next episode we'll be talking about the non-modifiable risk factors for breast cancer. Hello, my name once again is Dr. Samson Asala from the Medifem Multi-Specialist Hospital and Fertility Center. Today on the tips about breast cancer, we are going to continue on risk factors. The last time we mentioned that there are two types of risk factors, modifiable and non-modifiable risk factors. Today we want to talk a bit more about the non-modifiable risk factors. Non-modifiable risk factors are risk factors we can do nothing about. Examples include a family history of cancer, starting your menses early, a late menopause, age greater than 40, and female sex. There's nothing you can do about these risk factors because that is just the way you are. However, it's important to note these because they put you at increased chance of getting breast cancer. It will surprise you to know that over 50% of women who develop breast cancer had only two risk factors. Those were age greater than 40 and female gender. Those are non-modifiable risk factors. So it is really important that all women above the age of 40 are screened for breast cancer. Thank you. Join us again next time for another episode on tips about breast cancer.
Auntie, Pacho ete sen.
Pacho you.
Pacho, mami hu din.
Your friend me Mavis, Asante.
Na Pacho, would you may say how many years?
Me shall say almost 6 years in me.
6 years. Auntie, when they introduce you to Ejume?
Me mame. Na mame na o de nyema fi kwan so ba. Auntie na me ba na nchen wa ha ba sisi ano. Ajena home kakra nti me na meye.
No, I only for 6 years. Okay. Nti me show abrabo mu kakra o sempempi ye wo abofra nye ya. Unye nyina o si o mi ko school esanse pese bia me ye doctor, pese me ye lawyer, pese me ye seni se unye na den da we ni so se wo be da achi.
Oh, me nyi ni de na nka pese me ko school na eja mbe ye aban adwuma. Ana se na me pese me ton ade but abanesa
aban adwuma nti se ebin.
Oh, say school na me depend school na me ko no se metime ko ya anka ebia meye ebia secretary ana nursing ana se bibi what you say
nti se school no went me anko bi kra.
Oh, me wie SS mo but na me nya boafo bi ama wanto ameso
ko do SS na vocational school na wo for we.
Oh, ma wo for wo ho. Ma wo for wo ho. Me ma me wo papa wo ho. But na nyeme mu eye den kakra.
Mo do so ana.
Oh, ye no so sa but obey ne den.
Wunyi wo nkan he ya.
Da bi me nyi wo su ho.
At what point na o sha se o no ma me ba beton ade wo nkan ha.
Oh. me di kan ba kra na me ko Togo ko fanye ma banti nyema ba down ya de na me start say me ben me ma me wa hase na me na aye market
so udi kan ka say wo na won pese obeton ade nti
nye no na na wo me ne so
nti reality no say sisi ade wo ni choice bia we na wo say ye no de ni sen
me okay maji atumo brego because I nya emwa
abe uso o sha say 6 years ni nti den na betumi aka say me Mavis me share adwuma we asi metumi aye say ni say e de afrim
me share adwuma na si ansa na me ware nyame adom bibia ye fine mama me okay
unya say unya nsi wo dan ni na unya
eguso
asetan de bibia nso eyeboko
I said your mind mo ayed nya easy emo ayed yo nso nyame wo ho nyame beye ye bompa ya I hope say nyame beye bibia
wa be wo say olonka ba ko ye 20 cedis in a day oba ahena utumi eton
I told the beer market in the told the beer, ye told the beer, and they say in the market in your cry. Marketing, yes, a market, yeah, me 5 bags, but and that 3 pen a maton.
5 bags, now they saying,
say 1 bag, and price says first near the Maya 300, say 35. It's me ton. Say no me fa wo me be fa e wo omonchen na maton ti me wi ana me disika no eko what you say nti de be ba so na be ye media
nti wedro pepe so bi wa brabo ma ohun say when nu ho say nya na nka pese o ye no wentumi anye
o ye me no me ho wa brabo mo kra not we ya makase me no me ho no
ebia unse ebia misuku me classmate o mo ameni o mo ko school no unse mo do level bi na
say ne me hu ne say once a we ye adwuma nko ade so ono na wako school no okọ a unse utimi ko bi what you say market any school no difference bi e ne mo saa o kwa ho bibi ba na wo kwa utimi ko unse obetimi akọ bi betimi a present o ho sene a obi a wako school kra so ye den e present no ho no nti me no me ho that be pressure be any baby because obi wo kra wo ho a wako school so they do baby and your market no o ti me eye ne ho we chen obi a wako school pen nti me no me ho kra
the market ne ekoye mo ya o seriously
eno ni adwuma me se meye nti se ne etie bia se yo se nyo e wo se me ma me
Race number 1. /13/2022 dated 29th March 2022. There's also the case of Ken Kranchi versus Attorney General. Writ number J1 /16/2023. Ruling of the court dated 14th November 2023. All these were writs which invoked the original jurisdiction of the court to interpret the Constitution. This court held that a violation of the rules nullified the proceedings. We also want to emphasize that by the decision of this court in the case of National Investment Bank number 1, there's a Standard Offshore Trust Company number 1, reported in the 2017 Supreme Court of Ghana Law Report at page 707. The court held that where the provisions in the rules of court use the word shall, it is mandatory and should be enforced. we urge the court to follow these decisions. We should also add that where the irregularity complained about arises from originating proceedings, like in this particular matter, the court has also been consistent that such irregularities cannot be cured. So, several reasons why. In rates, recently the court has made the point, nullifying the rates. Secondly, the rules are mandatory, and this same court says that when they are mandatory, they will be enforced. And finally, where the proceedings are originating in nature, there can be no waiver. There can be no waiver. That's the recent position of the court. But we're saying also that even if it were curable, which it is not, the court's jurisdiction, substantive jurisdiction, to entertain the matter as a whole was not properly invoked. Was not properly invoked because the court lacked jurisdiction to entertain the matter as a matter, the purpose of which is to determine whether or not the seat of a member of parliament is vacant. That matter be not deviated with the membership of a person in parliament. That belongs in the realm of the High Court, not this court. But I want to emphasize the point that admittedly in every instance they would say that the facts on the basis of which they are before this court arise. There will be a dispute between two people regarding whether or not the person properly is a member of parliament or not, and that has provisions. It won't make it a dispute. The original jurisdiction of the court. What I'm saying is that wherever the question arises as to whether or not a person is properly a member of parliament, whether he ceases to be seat is vacant. There will be different positions, but the Constitution says it's the High Court that must determine that matter. And in this particular instance, the question is whether the parliamentarians who are the subject of the instant suit, their seats have become vacant. And the Constitution clarifies the position by telling the High Court the instances in which those seats will be deemed vacant. It's a cost-carpeting situation. So it's a matter of evidence for the High Court to go into and find out whether the facts establishing those circumstances in Article 97 have arisen or not. It's not a question of interpretation. Which is properly the type of order or ruling which is the subject of the court's orders for stay of execution. At the very best, it's an administrative decision. It's not a judicial. It was not based on any judicial determination of any matter. Linked to that fact is the trite position that when we say stay of execution, we don't say it as a semantic expression by way of semantics. It is based on the rules of the court. It's a statutory position that certain matters are liable to be progressed by way of what the law says, execution. And the law defines how to execute things. Not from anywhere, but from the judgments of courts. The Speaker's ruling is not one of them.
The Speaker's ruling is not executable.
It's not executable within the meaning of the rules that govern the practice before this court and any other court for that matter. Of time, there was an intervening Monday before Parliament would next sit, and the first defendant would at least have been given an opportunity on that Monday, however short it is, to representation. On the grounds basis for that application. And so that's the reason why we contend that the application did not properly come within the exception to the rule on notice, because it was always possible given the facts of this case. On the basis of that, we further contend that the order was also made in breach of justice. Because when it came before the court, within an hour and a half or so after it was filed, the court could have directed that the first defendant to be heard on the coming Monday. So that the facts will be properly put before the court to enable the court to reach a proper conclusion. We further submit also on another ground that the rules and practice did not permit the type of order that was given by the court. Bearing in mind the first rule again, as was espoused by the court in Barclays Bank and Ghana Cable, that ex parte, bear in mind the principles laid down by the court. One each of the Constitution in the first belief. So an issue of interpretation is not sought for in respect of that particular belief. Yes.
This is your view.
Yes. My loss the relief zone cover honorable
that you spent 16 minutes.
Oh, really? I'll be winding up, my lady. I'm sorry. They would realize that the release covered the honorable Peter Yao. Aka, the MDC MP. Do not cover him. The release of the substantive rate do not cover him. But the application covers him and the orders cover him. So on that ground we say even the orders exceeded the scope of the application and the nature of the suit.
Hold on, the scope of the application or the scope of the release?
The scope of the release in the substantive
action.
Yes. And because it exceeded that, the application could not have been in respect of the substantive suit. We finally submit that because this matter was brought ex parte, the balance of convenience was not properly employed by the court, which is the ground on which the court made this decision, because of the fact that allegations were made about what was likely to happen in there was no foundation whatsoever for it. And so the court jurisdiction wasn't properly invoked, especially in respect of Articles 1913, which requires a fair hearing as a constitutional right to be accorded to every person, and the provisions of 296A and B, which require the court to
exercise
discretion in a particular manner.
Has once again relinquished his privilege.
My Lord,
you to argue half and leave half to Mr. Bedu. It will not happen. So have you relinquished your
argue this?
Thank you.
If the subsequently there's another matter.
Thank you very much, Mr. Bedu. Please continue. Your 10 minutes are running.
By relying on
We oppose the application by relying on our affidavit. Position filed on the 29th of October 2024, and we rely on all the depositions therein. Of notable concern to us is our paragraph 4, which is a counter to the contention by the first defendant applicant that the procedure adopted by us in commencing this action is questionable. Is this the affidavit of John Bosman? That is so, my lord. Go on. Lord, indeed. So we wish to advert the mind of the court to rules 45 and 46 of CI 16. Which is a provision for invoking the original jurisdiction of the Supreme Court. The rule provides that
motion or notice for interlocutory injunction on the Speaker of Parliament through the legal office of Parliament. Was good service. Was good service, despite the fact that it was left on the table of the officer who received the process. This was a day before the ruling of the Speaker of Parliament. It was done on the 16th October 2024, and the Speaker went ahead on the 17th of October 2024. So our humble contention is that at the material time incidental to the delivery of the ruling, the Speaker was fixed with knowledge of the pendency of the action before this honorable court. Yet he went ahead in disregard. We found at paragraphs 18 and 19 of our affidavit in opposition. Where again we've taken the pain to state that October 2024 granting a stay of execution against the ruling of the Speaker of Parliament does not amount to any interference with the procedures and business of Parliament. The Lord's per Article 2, Clause 1 of the 1992 Constitution an invocation of the exclusive original jurisdiction of this apex court is the right of every citizen of Ghana. More so when the applicant in this instance any adjudicating authority Ghana, regardless of being a separate arm of government. Lord, our faith ground is contained in paragraph 21 and 22 offer affidavits in opposition. Given our resorting to an ex parte application. Paragraph 21 and 22 of our affidavit in opposition. Lord, we have stated therein that we anticipate potential irreparable damage and mischief if the order was allowed to stay. And this action was to commence in the ordinary way. Lord, we fortified our submission by relying on Order 25-8 of CI 47. Lord, the said Order 25-8 identifies yes, of CI 47. Lord, let me what we intend saying over there is that there was an element of agency. There was an element of agency associated with the application and the need for a dispatch response. Any mischief achieved by the ruling of the Speaker was irreparable, considering the fact that those 4 constituencies would have been bereft of representation in Parliament between now and its dissolution. per Rule 5 of CI 16, this honorable court is the only court of the land seized with the power, seized with the power to prescribe rules of practice and procedure. So regardless of the fact that granting an ex parte application for limited number of days is not stated in the rules of the Supreme Court, Lord, the court was all the same vested with the power to make the order it made, and nothing unlawful, unprocedural could be raised in respect of the order of the court. More so, my Lord, Article 2, Clause 2 1992 Constitution give this honorable court the power to make appropriate directions that it may consider appropriate giving effect or enabling effect to a declaration. Lord, we're saying that in so long as those affected members of parliament were not given the opportunity to state their side of the story before the speaker made his order, they
There are many people here who are not here because of this case.
I know.
Their work needs to get done.
Lady, I'm sorry. All said and done, it is the standpoint of the plaintiff respondent in this case that he has not breached any procedure in seeking the order is now being sought to be set aside. Neither is his action in breach of any substantive law or the Constitution governing the Republic, but granted without admission that there was even one. Rule 79 and Order 81 Rule 79 of CI 16 and Order 81 of CI 47. Lord, makes him curable by this honorable court. Lord, I rest my case. I'm grateful. And my Lord, whether executable or not, an order of stay is made to operate, and obey is not for
we are opposed to the application relies strictly on points of law. Before I proceed, may I respectfully announce a reconstitution of our representation. It will be done by the Deputy Attorney General, Dana Asunabadapa. So it's a full house. The Office of Attorney General is properly constituted. We submit that the instant application is offensive to the rules of procedure of this honorable court, is unknown to the laws governing the jurisdiction of the court. The first point we make respectfully is that the Constitution has set out in clear terms the manner in which a challenge to the decision of the court can be made. This application completely violates the laid down procedure for challenging a decision of the court in the Constitution. Article 133 clause 1 of the Constitution vests the Supreme Court with power to, and I quote, review any decision made or given by it on such grounds and subject to such conditions as may be prescribed by rules of court. Respectfully, the instant application seeks an order setting aside the process and proceedings of the court and vacating the order of the court. Respectfully, the decision in question was in exercise of right. Respectfully, Article 183 clause 1. The 183, I'm sorry. 133. The review is of the court. Especially, my contention is that this provision is a rule under which a person aggrieved by a decision of the court comes by to seek a review or variation of the decision. The instant application is not an application for review. It doesn't invoke the court's review powers and is therefore unknown to the laws governing the jurisdiction of the court. Especially Article 134 also vests the Supreme Court with the same powers of review of a decision of a single justice. Indeed, the decision in question was not by a single justice. But the point I seek to make is that whenever a decision of the court is being sought to be reviewed, varied or discharged, the procedure for doing so is as set out in the Constitution. And this is not an invocation of any of those procedures. The second point we make is that the application mixes up grounds for a substantive defense to the action with matters that, in the view of the first defendant, constitutes a basis for a setting aside of the service. And this respectfully is wrong. The court will notice that on the face of the motion paper, the grounds for the application are stated as, now respectfully I'll quote, I'll just be quick about it. The rate by which the plaintiff has purportedly invoked the court's original jurisdiction is incompetent. The court has no jurisdiction to detain the suit before the court. The court has no jurisdiction to stay execution of a will of the Speaker of the Parliament of Ghana. Respectfully, paragraphs 12 to 18 of the affidavit in support also raise matters which constitute a substantive defense to the action. And I respectfully will quote paragraph 12. So the words used in Article 97 clause 1, paragraphs J and H of the Constitution are clear, unambiguous, and have no disputed meaning, and no basis exists in the processes filed for assuming that there's dispute. Then paragraph 13 says the words used in the provisions of Article 97 clause 1, paragraphs J and H simply mean what they say. That is to say, when a member of Parliament leaves a party on the ticket of which they are elected to Parliament, to join a political party or to become an independent member of parliament, or when a member of parliament elected as an independent member of parliament joins a political party, they shall vacate their seat. Respectfully, I will turn over to paragraph 29 to 32.
No, you have 10 minutes.
Yes, please. My lady, I'm still well within the term. I'm sorry. So, it says, paragraph 31. Further, the 19th Constitution of the Republic of Ghana provides for the well-known separation of powers doctrine, whereby the scope of the powers of each arm of government is set out, and no arm of government is expected to overstep its bounds. The same is the defendant takes the view that the writ does not invoke the decision of the court because, in the view of the defendant, the words of the Constitution are clear. The rules do not permit. We have to be in a statement of case filed at the point raised for determination by the court. And the court will notice that indeed that issue is actually one of the issues set out by the second defendant for determination. The second defendant does the Attorney General filed issues for determination in this matter, and those are issues raised in the for determination by the court. Especially, indeed, the application and misconceives the Supreme Court's original decision. And I made a point that indeed the court would notice that Article 2, Clause 1 of the Constitution constitutes the principal mechanism, with all respect, for enforcing the Constitution. And in examining Article 2, Clause 1, I pray the court not to look only at the article, but to even read it with Article 3, Clause 1 of the Constitution. Article 3 of the Constitution, Article 3, the whole of Article 3 of the Constitution, imposes a duty on all citizens to defend the Constitution at all times. Respectfully, there is no better mechanism for defending the Constitution by seeking an interpretation of the Constitution whenever a provision of the Constitution is in contention or a controversy has arisen in respect of that provision. Clearly, the meaning of Article 97, Clause 1, paragraphs J and H, as advanced by my learned friend, Counsel for Defense Defendant, on which he says are clear, have been contradicted by the plaintiff in this case. And indeed, I have also duly filed a similar case in it, and totally his understanding, with all respect, is wrong. There cannot be a more demonstrable case for a controversy as having arisen in respect of a provision of the Constitution than the instant case. But my respectful submission is that indeed it will be a recipe for chaos, lawlessness, and a danger to the security of the state for a person to contend that merely on account of his own understanding of the Constitution, which he says are clear, a writ issued duly invoking the decision of the Supreme Court has to be set aside. And that would be the basis for lawless conduct. And this honorable court owes a duty not to encourage him. I'm fortified in this proposition by the locus classicus on the matter to follow an Attorney General reported in 1980 Ghana report at page 637. And where the Supreme Court stated clearly that whenever a controversy has arisen in respect of a provision of the Constitution, it is a basis for the invocation of the court's original decision. Respectfully, the points I make today are not points being sought to be established today. They are matters that have been long established 40 years ago in this honorable court. I quote from page 650 of the provision. And indeed, it was also a controversy regarding a decision by Parliament. Parliament had actually made a decision to subject the Chief Justice of the Republic to vetting. The Chief Justice had also even acceded to that process. The Supreme Court said that, notwithstanding the Chief Justice's decision, insofar as that decision was unconstitutional, it could form the side matter of the original decision of the Supreme Court. But the court stated that there's a controversy regarding the status of the incumbent Chief Justice, the determination of which depends upon an interpretation of the Constitution. Once there's a controversy, a justiciable issue, we believe that under the wing of interpretation as contained in paragraph A of clause 1 of article 118, the court has jurisdiction to detain the issue raised by the plaintiff's right, and the plaintiff is thus properly before the court. And respectfully, the court went ahead to make the point that in a constitutional action, the community of interest is with the constitution. There's even no such thing as a plaintiff or a defendant, and therefore the writ which mentioned some members of parliament, there must be a demonstration of an interest in them. There's no such thing as that. Indeed, the plaintiff, with all respect, could have omitted reference to any member of parliament and have just stated a question for determination by the court whether upon a true and proper interpretation of Article 97 clause 1 paragraphs J and H of the Constitution, a seat of a member of parliament becomes vacant upon the occurrence of A and B. And that is it. And the court will have been seized with the decision. My lady, the first defendant makes reference to an alleged denial of the right to a hearing auditory pattern by the filing of a motion party. My respectful quick answer is that indeed the law even envisages such a procedure, and there cannot be a denial of any natural justice, right to natural justice, in the court entertaining an application for application ex parte. And if indeed it was the case that whenever a motion ex parte is brought, there is a denial of the right to a hearing, then indeed the court ought to scrap from its procedures and rules motions ex parte. This submission is totally incongruous, totally offensive to the long or the age-old practice in this honorable court. Respectfully, I would respond to the contention made by my left friend that there was an understanding of the CJ with the Speaker of Parliament and all that. I will not seek to even go into the merits of the understanding. But the point must be made that constitutionally.
No, hold on, please.
Right.
I think that for the benefit of the public
right,
of this nation,
right,
it is important to address the facts behind that matter.
Right.
SBB did, because there had been a circular in 2021 to regulate service on members of parliament. And indeed, the Speaker of Parliament invited me as Chief Justice to discuss the return to that regulation. So I reviewed what my predecessor did, and I issued a circular. If anything, I think your submissions may address the import, the legal import, and nothing more.
Right. Maybe in addressing the legal import of that circular, I would note respectfully that I'm just looking for a circular that what is paramount before the court in an action of this nature is the proper interpretation of the Constitution. And indeed, as held in before an attorney general, even if, assuming with her admitting, even if the CG had written such a letter, for me, with all respect, it's immaterial.
It's a circular.
The circular, written such a circular, it is immaterial for me. It is a construction of the words of the Constitution that matter. Before an attorney general even indicated that this Chief Justice, who had lent himself to the process, which was subsequently pronounced upon as unconstitutional by the court, could not have waived any right whatsoever, because there's no such thing as estoppel under the Constitution. And indeed, I look at the provisions, the words in Articles 117 and 118. All it says is that civil or criminal processes coming from any court or place out of parliament shall not be served on or executed in relation to the speaker or a member of the clerk of parliament while he is on his way to attending at or returning from any proceedings of parliament. In my respectful view, I do not see mandate in Article 112. 117. I do not see Monday there. I do not see Tuesday to Friday. I do not see. All that must be understood clearly. Irrespective of that circular, in my respectful view, I, the Attenderer, can, or any citizen of the land, having in both the Supreme Court, can serve the process on a member of parliament, a speaker of parliament, or a clerk to parliament, except when he's on his way to parliament or returning from parliament. That is what it says. But again, there is an attempt to suggest, and it was implied in the submissions relating to the Supreme Court overstepping its bounds and what have you, that Parliament of Ghana, I know I have the right to reply, but it's done over 25 minutes. Yeah. We've been checking.
Attorney General, you have 1 minute left.
But I know I have the right to reply, especially that he got up only on points of law. So but he's exceeding.
Maybe, yes, the point of law maybe because of application.
Please don't waste your 1 minute.
Maybe the point I'm making is that the Supreme Court's judicial review powers, pursuant to Articles 2 Clause 1 and 130 Clause 1, extend to any authority, institution of state, or any individual in the country. No arm of government, no institution of state, and definitely no individual is exempt from it. Indeed, the president himself is even subject to the Supreme Court's judicial review powers under the Constitution. And the Constitution spells out the consequences for a failure to obey decisions and orders and directives of the Supreme Court. That is in Article 2, Clause 4. Failure to obey or carry out the terms of an order or direction made or given under Clause 2 of this article constitutes a high command under this Constitution and shall, in the case of the President or Vice President, constitute a ground for removal from office under this Constitution. So clearly, the powers of the court can never be questioned at all. And it is for this reason that the Supreme Court, to form an Attenderer, and further fortified by G.H. Mensah and Attenderer, reported in 1996, Supreme Court of Ghana law report, stated clearly that in Ghana, there's even no such thing as a political person. The court can call into question any act or omission of any person at all, insofar as it's in violation of the Constitution. So the contention by my left friend, Counsel for Fair Defendants, that it was an administrative decision of the Speaker. And so, with all respect, I'll ask, and so what? Any administrative decision of a person or authority which comes in contravention of the Constitution is amenable to the court's judicial review powers. I simply submit that the application before you is totally offensive to all rules and procedure of this honorable court. It's unknown to the laws of Ghana and must be dismissed. I pray accordingly.
Just some short points of law, especially that they were made on points of law, and I'll be very short. First point, that the application is unknown to any rule of procedure and offensive and all of that. First, the simple answer. Since the days of Mosi and Bajina, elementary, first rule in the civil procedure classes, if an order is a nullity, you can come by any procedure to set it aside. It remains the law following from he likes to cite cases of vintage. He says over 40 years. You calculate when Mosi and Bajina was decided, 1963.
Mr. Sorry, all your juniors are here.
They were here when they say there is a misconception and a misunderstanding. They have remained here. And this is the clearest example of a misconception and misunderstanding. I said from 1963 up to 2000, and we are now in 2020 something. It remains the law, elementary first rule. 2, that I'm challenging the jurisdiction of the courts, and I'm saying, with all due respect, some matters don't fall within the jurisdiction.
Some matters do not.
That this matter doesn't fall within the jurisdiction of the court, and that I'm mixing matters that should go through the defense and then an objection.
Now the point made is that if you are urging that the writ is incompetent, that should be separated from submitting a defense to the substantive action. That's one. Second, that if this court gives an order and you wish for it to be vacated, reversed, varied, discharged, the onus is on you to bring an application under the review jurisdiction of the court, and not an application such as you have crafted.
Yes, madam.
That's the point.
The procedure is that the rules of review aside, this court delivers judgment according to three main yardsticks: statute law, common law, and the well-known practice of the courts. That has been consistent. And the well-known practice of the court and the common law is that you come and set it aside. And I'm saying way back from everything up to date, that remains the law. So this is not a point. Secondly, if I am challenging the jurisdiction of the court, there are two ways and several ways. Elementary civil procedure, I can take it in limine or put it in my defense, and I'm taking it in limine. Another elementary grounds. Now let me just deal with the Article 2:1 point Tandrosley said. In all of the cases involving Article 99, the jurisdiction of the court to determine a membership of Parliament, they also come under Article 2:1. But the court has always said that yes, if they didn't invoke Article 2:1, they wouldn't have been here. But the court has said, look, we will keep our streams clear. Then you cite to for an Attorney General and about the fact that the matter is within.
Your 1 minute is up.
Well, there are other cases. More recent vintage, they all say clearly that that would not be a reason for the court to entertain jurisdiction. And that's for the secular. My Lord, the Chief Justice must have had reason to issue it, and the Speaker must have had reason to respect it.
And it has constitutional power.
If it's not constitutional, he knows what to do. He should come and declare it unconstitutional. But otherwise, then the Speaker should feel deceived by it. That's the point.
You are done.
I'm done. If my time was up, then.
The case is stood down for the court to rule.
All rise.
very high. That's why I said I compared the matter of 22nd